Hahn versus Court of Appeals 266 SCRA 537 January 22, 1997. Facts of the case: Petitioner Alfred Hahn executed in favor of private respondent BMW a deed of assignment with special power of attorney. Per the agreement, the parties continued business relations as has been usual in the past without a formal contract. On February 16, 1993, the petitioner was informed that BMW was arranging to grant exclusive dealership of BMW cars and products to CMC. Petitioner received confirmation of the information from the BMW, which in a letter expressed dissatisfaction with various aspects of petitioner's business, mentioning among other things decline in sales, deteriorating services, and inadequate showroom and warehouse facilities, and petitioner's alleged failure to comply with the standards for an exclusive BMW dealer. Nonetheless, BMW expressed willingness to continue business relations with the petitioner on the basis of a standard BMW importer contract. Otherwise, it said if this was not acceptable to petitioner, BMW would have no alternative but to terminate petitioner's exclusive dealership. Petitioner protested, and because of his insistence, BMW withdrew its offer of a standard importer contract and terminated the exclusive dealership or dealer relationship effective June 30, 1993. In a conference in Singapore for regional importers, BMW proposed that Hahn and CMC jointly import and distribute BMW cars and parts which Hahn found unacceptable. On May 14, 1993, he filed a complaint for the specific performance and damages to compel BMW to continue the exclusive dealership. He later amended complaint to include an application for temporary restraining order and for writs of preliminary, mandatory, and prohibitory injunction to enjoin BMW from terminating his exclusive dealership. RTC issued a temporary restraining order. The hearing proceeded ex parte with petitioner Hahn testifying. It then issued an order granting the writ of preliminary injunction upon the filing of a bond. BMW moved to dismiss the case. It contended that Hahn was not its agent. Hahn opposed the motion. The trial court deferred resolution of the motion to dismiss until after trial. Without seeking reconsideration of the order, BMW filed a petition for certiorari with the Court of Appeals, and the Court of Appeals found the trial court guilty of grave abuse of discretion in deferring resolution of the motion to dismiss. After stating that any ruling which the trial court might make on the motion to dismiss would anyway be elevated to it on appeal, the Court of Appeals itself resolved the motion. It ruled that BMW was not doing business in the country and therefore jurisdiction over it could not be acquired through service of summons on the DTI pursuant to Rule 14, Section 14. The court upheld private respondent's contention that Hahn acted in his own name and for his own account and independently of BMW. It held that petitioner was a mere indenter or broker and not an agent. Consequently, CA or Court of Appeals dismissed petitioner's complaint. Hence, the current petition for review of the decision of the CA dismissing a complaint for specific performance which petitioner had filed against private respondent on the ground that the RTC did not acquire jurisdiction over private respondent, a non-resident foreign corporation, and of the appellate court's order denying petitioner's motion for reconsideration. Now, what is the issue? The issue here is whether or not Alfred Hahn, the petitioner, is an agent of BMW in the Philippines. The ruling of the court is yes, Alfred Hahn is an agent of BMW. Allegations of the amended complaint show there is nothing to support the appellate court's finding that Hahn solicited orders alone and for his own account and without interference from, let alone direction of BMW. To the contrary, Hahn claimed he took orders for BMW cars and transmitted them to BMW. Upon receipt of the orders, BMW fixed the down payment and pricing charges, notified Hahn of the scheduled production month for the orders, and reconfirmed the orders by signing and returning to Hahn the acceptance sheets. Payment was made by the buyer directly to BMW. Title to cars purchased and passed directly to the buyer, and Hahn never paid for the purchase price of BMW cars sold in the Philippines. Hahn was credited with a commission equal to 14% of the purchase price upon the invoicing of a vehicle order by BMW. Upon confirmation in writing that the vehicles had been registered in the Philippines and serviced by Hahn, Hahn received an additional 3% of the full purchase price. Hahn performed after-sales services, including warranty services, for which he received reimbursement from BMW. All orders were on invoices and forms of BMW. These allegations were substantially admitted by BMW, which in its petition for certiorari before the Court of Appeals stated that as soon as the vehicles are fully manufactured and full payment of the purchase prices are made, the vehicles are shipped to the Philippines. The bills of lading are made up in the name of the purchasers, but Hahn Manila is therein indicated as the person to be notified. It is Hahn who picks up the vehicles from the Philippine ports for purposes of conducting pre-delivery inspections. Thereafter, he delivers the vehicles to the purchasers. As soon as BMW invoices the vehicle ordered, Hahn is credited with a commission of 14% of the full price. And as soon as he confirms in writing that the vehicles had been registered and had been serviced by him, he will receive an additional 3% of the full purchase price as commission. Contrary to the appellate court's conclusion, this arrangement shows an agency. An agent receives a commission upon the successful conclusion of a sale. On the other hand, a broker earns his pay merely by bringing the buyer and the seller together, even if no sale is eventually made. As to the service centers and showrooms, which he said he had put up at his own expense, Hahn said that he had to follow BMW specifications as exclusive dealer of BMW in the Philippines. According to Hahn, BMW periodically inspected the service centers to see to it that BMW standards were maintained. In addition, BMW held out private respondent Hahn as its exclusive distributor in the Philippines, even as it announced in the Asian region that Hahn was the official BMW agent in the Philippines. The decision of the Court of Appeals is reversed and the case is remanded to the trial court for further proceedings.